Hi, everyone. Come in, settle in. Good morning, almost good afternoon. Thank you so much for being our audience today. Very happy to be back here at CPDP in this excellent new location and to have the honor to convene this very important conversation today with true experts in our field. My name is Bianca. I'm Policy Manager for Global Privacy at the Future of Privacy Forum here in Brussels. And I'm delighted to first and foremost introduce our panelists today. I'm joined by Audrey Plonk, just to my left. Audrey is head of the Digital Economy Policy Division of the Directorate for Science, Technology and Innovation at the OECD. As head of division, Audrey is responsible for implementing the work program for the Committee on Digital Economy Policy and the Committee for Consumer Policy, as well as the management of the Directorate's Digital Economy Division. Prior to the OECD, Audrey was Senior Director for Global Security Policy at Intel and has been a guest lecturer at the University of California, among other expert roles. So welcome, Audrey. We're also joined by Emma Redmond. Emma is Associate General Counsel, Head of EU Privacy and Data Protection at OpenAI. She was formerly Global Head of Privacy and Chief Privacy Officer at Stripe, with previous roles as the Head of International Data Protection at both Ancestry and LinkedIn. Emma is an Adjunct Associate Professor of Law at University College Dublin and is also a member of the Government of Ireland's AI Advisory Council. Welcome, Emma. We're also joined by Bruno Bioni. Bruno is founder and director of Data Privacy Brazil, an organization dedicated to bringing a culture of data protection in Brazil and around the world. Bruno holds a PhD in commercial law, is the author of several data protection books, and is a member of Brazil's Federal Senate Committee on AI and Brazil's National Data Protection Council. Hi, Bruno. And last but certainly not least, Gregory Smolinek is Deputy Commissioner for Policy and Promotion in the Office of the Privacy Commissioner of Canada. The promotion program that Commissioner Smolinek works on aims to inform Canadians of their rights and how to exercise them and to bring organizations towards compliance with the law. Gregory leads the OPC Policy and Promotion team to develop practical information and guidance and in developing advice on specific initiatives. So welcome, everybody. We've come together here to discuss today some of the different regional and global approaches to AI regulation, what these developments spell for global regulatory alignment as we look towards interoperability, and whether we're seeing the emergence of a more international law on AI on the basis of shared principles. We're seeing that now is really the time that countries around the world are setting the tone for both binding and non-binding regulatory standards and regimes. And we could argue, and also what we'll explore in the panel today, that the developments are taking place really on two levels, the national and regional level, and more globally. At the regional level, what we're discussing a lot also at this conference is the EU AI Act. But beyond this, we also have Brazil's draft AI bill, President Biden's executive order on AI over in the US, the African Union's draft AI Continental strategy, which is a different approach that will set the tone for countries on the continent to develop national AI laws, but within a wider, more unified framework. And then on the second global level, what we're also seeing is different forms of multi-stakeholder dialogue that are really materializing with increasing momentum in international fora, including at the United Nations, the Council of Europe, the OECD, G7, G20, and the list go on. So the developments in this space are many, and we hope to make sense of some of them together for the next hour or so. Well, we will also keep in mind two things. The first is that the development and deployment of AI systems are cross-border in nature. So talking about regulatory alignment is deeply important, not only for legal certainty, but also for meaningful rights protection across borders. And the second thing will, of course, come to this from the ever-present role of data protection laws and practices in informing these evolving AI norms. So CPDP is also, as a conference at heart, a privacy and data protection conference, so we hope to keep true to that. So enough from me. We'll start nationally, regionally, and go to more global developments. And Bruno, I'd actually love to start with you, if I may ask you, What are you seeing in the approach to AI regulation in Brazil? Also in the wider context of legal cultures and frameworks in Latin America, are you seeing that this approach differs greatly to other regions? And what are some of the examples there?
Thank you so much, Bianca, also for the invitation and also for the great partnership between Future Privacy Forum and Data Privacy Brazil. We have been collaborating for several years, and also it's so much good and great to be here with you in one more year at the CPDP. Yeah, and with regards to your question, I think right now we are seeing a regulatory fervency worldwide, globally, and specifically in the region of Latin America. I think we should track specifically some kind of initiatives. Chile just proposed a AI regulatory initiative as well, which is very rooted in the UNESCO's principles with regards to AI ethical guidelines. Also, Rede Ibero-Americana of the data protection authorities in the region is trying to set up a common framework in order to strike what is the role of data protection authorities in this regulatory game. And Brazil is also pushing for a regulation this year. It is expected to conclude this process by the end of the year, because then we can also not only conclude the G20 Brazilian presence, which must be prioritized AI as well, but also do our national homework in order to strike a rights-based approach for our regulatory effort and also appetite. And trying to establish a comparison between the Brazilian regulatory approach with others, specifically with regards to the EU AI Act, I think both are very framed in this idea of a risk-based approach, but also trying to conciliate, strike a proper balance with a rights-based approach. And one thing that we are not, I think, not, let's say, developing or assessing in a deep way is that risk-based approach is not a monolithic. We can and we should explore a little bit more the nuances and difference behind it. What I mean by that, like if you develop from the environmental regulatory experience by applying a risk-based approach, we could see that the big challenge was trying to strike a balance in terms of regulatory interoperability that would fortify a democratic control, social control, to define and to assess what are the tolerable risks in our society. So for instance, in Brazil, we have like a really solid environmental framework that says any kind of assessments in the environmental initiative should be public by default, or at least we should have some conversation for those kind of assessments be under public scrutiny. So that's inspired a lot how the Brazil is thinking an AI regulatory approach by saying in a stronger way that such kind of tools, algorithmic impact assessment, must be public by default, and also should be framed in a more participatory method or model. So, for instance, when we have like a specific environmental initiative in Brazil, we should also have public hearings in order to hear the society, the group that is going to be affected, to raise their own concerns. So if you establish a comparison between the Brazilian AI regulatory proposal, we have a specific chapter targeted to the public sector, and that kind of public deliberation is even more silent if you consider that kind of approach that is being framed in the Brazilian perspective. So also, the latest version that was released almost 3 weeks ago developed and evolved a lot in order to raise some political and normative language, what means regulate AI in a country like Brazil that is within the global south and also face very unequal and asymmetrical structural dynamics such as racism in Brazil, because there we are seeing a deployment of several facial recognition systems for the public security. And of course, there are a lot of bias on it. And then the consequence, the side effects are terrible because the black community in Brazil is being strongly and unequal affected by it. So for instance, how we try to respond on it in a broader way in the Brazilian regulatory perspective by assigning strong principles, but also trying to assign the role of indirect discrimination as a core principle for our law as well. So if you establish that kind of overview in terms of a panoramic analysis in the Brazilian regulatory perspective, we could see how the language, the normative language, I think it is a more rights-based approach than others that we are seeing in the world. For instance, we have the so-called umbrella terminology, which is the vulnerability or vulnerable groups, because at the end of the day, we should respond the inequalities, not only thinking about race, but also gender, but also other vulnerabilities, because we could and should develop this from an intersectional perspective. So it's very different when we are talking about some kind of bias with regards a white man or with regards a black man, and then we plus and add, for instance, the variety of gender. And we are seeing this, for instance, by the application of AI for employment process and recruiting process and so forth. And lastly, but not least, also the latest version try to strike a balance by having a comprehensive law with some structure that could open avenue and room for a sectoral approach as well. So the so-called CIA, which is the Brazilian Internet Governance System, assigns for one specific regulator the role to coordinate, not to monopolize the enforcement of the law, by setting general guidance, normative guidance, rooted in a human rights approach, and calling the sectoral regulators, such as the telecom regulators, such as the financial regulators, to define and to make more concrete such comprehensive rights and duties according to the context of each specific economic sector. So that's like also one of the main challenges, how we are going to have another transversal law, such as data protections during the years, but now trying to fulfill a gap in order that we could have like a more substantive approach, substantive protection by disputing the enforcement of the law in the key areas, for instance, for a welfare state, health, financial inclusion, and so forth. So I think that is, let's say, the Brazilian flavor that we are putting in this global conversation, and I'm more than glad to give further details after this panel or during the second round. So thank you so much, Bianca, for the invitation once again.
Thank you, Bruno. I think really interesting, and I think it will be especially interesting to see whether Brazil's approach will set the tone for other countries in Latin America over the following months and years. So thank you so much for this initial overview. Commissioner Smolinak, I'd actually like to turn to you next for a different perspective. Canada has quite recently proposed its Artificial Intelligence and Data Act. Well, this is not directly a privacy law, as we know. Canada's privacy law, the CCPA, would of course continue to apply to any processing of personal data in the context of AI systems. So we'd be really curious to hear from your perspective and experiences as a privacy regulator, how do you see the role of privacy and data protection in these ongoing conversations on AI regulation in Canada and beyond, particularly in what feels like a very crucial moment right now?
Thank you, Bianca, and thank you for inviting the OPC to this panel. Good afternoon, everybody. I'm Gregory. I'm going to give you a little bit of an overview of what's been going on in Canada, both nationally and in terms of the Office of the Privacy Commissioner of Canada's initiatives internationally related to AI as well. First, to set the stage a little bit, our point of departure of our office and our commissioner, or commissioners even, the previous ones as well, has been that technologies, AI included, obviously have great benefits that they can offer to people and society, but as you'd expect from a data protection authority, technologies and new tools must be implemented in ways that respect privacy, equality, and other related human rights. It now seems like ancient history, but it wasn't that many years ago. In 2019, we launched a public consultation on AI with the aim of developing a proposed regulatory framework for artificial intelligence. That was 2019. And we published such a proposed regulatory framework. This is our ideas on how to regulate AI in 2020. That framework's available still on our website, and the ideas behind it were that an appropriate legal framework for AI would allow personal information to be used for public and legitimate business interests, including the training of AI, but only if privacy was entrenched in a proper human rights framework. That's been a key goal of our office as well, to reform Canadian law to ensure that it's centered in a human rights dimension. The other point was to create provisions specific to automated decision-making to ensure transparency and fairness, explanation and content, and to require businesses to demonstrate accountability. Demonstrable accountability was a key phrase, to the regulator upon request, ultimately through proactive inspections and other enforcement measures to ensure compliance. Moving forward a little bit to this year, actually. We launched a strategic plan which outlines the priorities of our Commissioner, Philippe Dufresne, for the next few years. One of the priorities is to protect privacy with maximum impact using existing laws. So that's a key point. Existing laws apply. Often in the discourses about how AI should be regulated, perhaps sometimes we elide the fact that there are laws already. Another priority is for the OPC's strategic plan is to look at how to address and advocate for privacy in a time of rapid technological changes. So we emphasize the importance of fostering a culture of privacy, encouraging privacy by design, and promoting innovation, while at the same time using innovation to protect fundamental rights to privacy, or the fundamental right to privacy. So to Bianca's comments about what's going on in Canada, in our legislature, in our parliament right now. So again, I repeat, an important consideration is that while Canada's privacy laws need to be modernized, the existing laws still apply, and they apply to AI systems, including generative AI products and services, and the OPC is prepared to enforce them. On the legislative front, there's a bill in front of our parliament right now that's in front of committees, going through what we call clause-by-clause assessments. Legislators are proposing amendments to the bill. And in fact, they're proposing a lot of amendments to the bill. The bill includes actually 3 statutes. It's kind of like an omnibus of 3 statutes. One is a modernized private sector privacy law, CPPA, Consumer Privacy Protection Act. Another one concerns a related tribunal. And then the third one, very operatically named ADA, is the Artificial Intelligence and Data Act, which aims to provide a regulatory framework for artificial intelligence. So ADA, the concept here is that the privacy law would apply to AI as well. So, and we would regulate the protection of data and privacy in the AI context as well. Now, we made 15 recommendations on the omnibus bill, 3 of which relate to AI specifically, and those are that we recommend ensuring that privacy risks are identified and mitigated by organizations for technologies such as AI. We recommend within the Privacy Act that the Privacy Impact Assessment, or PIA, be required for high-risk activities. Secondly, they aim to promote transparency and accountability, and we recommend that organizations be required to explain on request all predictions, recommendations, decisions made using automated decision-making, and not just those that could have a significant impact. And this would apply as well to profiling. And to permit greater efficiency and coordination, the OPC, our office, should be given the ability to coordinate better with domestic regulators, including a new regulator known as the Data Commissioner that is proposed under the AI Act. So that's where we stand. That clause by clause is happening now. They're sort of in the middle of it. Parliament will break for the summer. They'll resume their examination of the bill in the fall. And with any luck, they'll pass it before we have an election next year. As an example, by the way, to give some explanation here of high-risk activity, AI models should have the capability to analyze, infer, and predict aspects of individuals' behavior, interests, and even their emotions. That would be in the category of high risk. So anything that could provide insights about individuals, including whether they get, for instance, job offers, loans, pay higher insurance premiums, or are suspected of suspicious or unlawful behavior, would be categories of higher risk. The ADA bill provides significant authority to the government to define key aspects of the law by way of regulation. So a lot of the details are left to the development of regulations after the bill receives royal assent. So there's, with it left to determination in regulation would be what constitutes a high impact system, and determining measures specifically about the way data is to be anonymized and so on. So there's a lot left to be decided after the bill that gets through Parliament, which leaves a lot to be said about what needs to go into those regulations. So we're also calling for our office to have a meaningful role in the development of the regulations as well. A couple other points, just give you a little bit of a aperçu what else is going on. Our Treasury Board, which is Government of Canada central agency, they developed a guide for public institutions on the use of AI recently. They're actually encouraging federal public institutions to explore generative AI tools. It sets out parameters on the use of AI by federal institutions, generative AI. It reminds institutions about protecting privacy as well, some basic things, and it recommends starting with low-risk uses as well. A few words on international and domestic cooperation. So we're currently working with domestic and international counterparts on research and policy initiatives in the area of generative AI, and I'll have more to say about this later on. We're also, this is something that we, I guess, look to, for instance, British examples. We've developed a new cross-regulatory forum called the Canadian Digital Regulators Forum, which brings our office together with the Competition Bureau and our telecoms regulator. And in our inaugural year, this past year, we focused on generative AI as well. Provincially, territorially, so we have a federal office, but we have provincial and territorial privacy commissioners as well. We've been working with them as well. And one of the areas of cooperation is between our federal office, Quebec, British Columbia, and Alberta, is we have an ongoing investigation into privacy practices of OpenAI. So that's an ongoing investigation, and basically the investigation is seeking to establish whether OpenAI is compliant with Canadian law. This is a joint investigation between these four offices. Investigation's ongoing, and as a consequence, I can't share any further information about the investigation right now, but we aim to release our findings in the coming months. One more final point. There's a lot going on in the world of AI and privacy. I don't know if you realize that. Conferences are being renamed. Who knows what else going on? Another related AI development. Our federal government, our Department of Industry, launched a voluntary code of conduct on the responsible development and management of advanced generative AI systems last September. This is while the bill's going through Parliament, they suggested a voluntary code. So at that time, about a dozen companies and organizations, some of the organizations are industry associations involving like hundreds of other companies, signed up for the code. The code points to the G7 Declaration on AI and states that it does not in any way change existing legal obligations that organizations may have. And basically, we're supportive of codes of practice in general, in a general sense, but we also want to ensure that the codes are buttressed by strong and effective legislation. So we've heard through our government interlocutors that other G7 countries may be considering the release of similar voluntary codes as well. So that's a little bit of an overview of the the work we're doing so far, and I'll have more to say about some international initiatives as well.
Thank you. That's wonderful. Really interesting to hear that while there are these kind of hard law approaches, there are also these softer law initiatives like codes of practice, codes of conduct, and so on. So we can dive further into that in a little bit. But for now, I'd love to turn to you, Emma. We've heard both from Bruno and from Commissioner Smolinek with this kind of wider picture in mind. And it's certainly challenging to try to grapple with all of the regulatory developments. Also, in the EU, we have the broader EU digital strategy, with the DSA, the DMA, and the EU AI Act, and all of this in the context of how rapidly AI technologies and particularly generative AI tools are evolving. So I was wondering, what are some of the issues that you're paying attention to from your perspective, considering that a lot of the evolving tools are so cross-border in nature, and what is important from kind of your very practical perspective in terms of regulatory alignment on AI? Yeah, feel free to grab that.
So thank you for having me. There are so many things to think about as they were both kind of discussing all the amount of work that's been done over this. It's truly phenomenal, both by government, by organisations, by authorities. It's truly phenomenal when you actually take a step back and think of all of the work that's been done. So I think it's credit to a lot of people around the world as the technology moves faster. So I think it's worth maybe taking a step back and kind of a bit of a nod and acknowledgement in terms of what has been done. I think for us, there's a lot of listening and understanding that's going on as well. We were founded as a research lab where originally and well beyond 30th of November 2022 when ChatGPT became available, and so our how we approach matters hasn't changed in the sense that, as researchers and scientists, it's always so important to ensure that you analyze your work, you are transparent about it, you report your work, etc. So that, from that perspective, when you talk about kind of practical elements, that hasn't changed. Our system cards, for example, are available, and that's all there. But of course, the regulatory alignment is absolutely crucial in this, and we can hear all of these key words like comprehensive approach, soft law, codes of practice, liaising. I'm just making notes myself on this. The meaningful role that we can all have, the risk-based approach, these strong principles. These are all really, really strong concepts to work from. There's a whole plethora of ideas as regards how to approach it, and we've seen it all out there. But really, this notion of global harmonisation is so important. We talked about this before, of course, when it came to GDPR, and we still do in terms of how does that all come together. And there's no real answer, I think, or certainly what I've seen, but what you're seeing is just a lot of effort that people, organisations and governments and bodies are putting together, again, which is really admirable. Look, it's in the context of evolving and fast-paced change. There is no doubt about that. I don't have time to go around the world, but obviously the EU has been like a star player in terms of the AI Act and the first proper attempt at a standalone regulation for AI. Truly phenomenal. All the work that's been done, of course, in Canada, Australia is coming out, of course. Even in the US, obviously slower pace there, but we can see efforts in terms of the Connecticut SB, in terms of Colorado, and so you're seeing it all kind of come together. And then, of course, you look at the work in terms of the G7 Hiroshima Code of Conduct and so on, and of course the work on OECD, which has been immense. So all of that is coming together, and so where does that go? Like with the AI Act, you can't put a line in the sand and say, right, off we go. It's about understanding those systemic risks and getting more intel in terms of how that actually will work and codes of practice. And that involves everyone kind of working and coming together in that respect. There's several practical areas, though, I think, where especially with the AI Act, it can inform a lot of the kind of global harmonization approach, perhaps. So if you look at risk classification, of course, being the obvious one from the AI Act, and how that interpretation can be translated on a global level, taking into account all of those particular codes, for example, that we're proposing. Then you have this notion of data governance and transfer, and we saw that actually with GDPR and that extraterritorial effect that it has, because that idea that travels with European citizens and those protections travel. So that's another aspect to think about with this. You're also looking at the transparency and accountability. Like, these are all words we have already in our back pocket, which we can, and those tools that we can use, and I'll chat about those later. So that's another kind of practical area which can really be, be assessed. Again, I mentioned the fact, we're a research lab and how we, publish our system cards and so on. So that's an example there. But this is very much a broader approach for everyone in terms of transparency and accountability. They're such loaded words, but in practical terms, how to actually go about that. The key, though, is, I think, this notion of harmonisation. I mentioned it already. It's such a key word in order to get this concept right. Each piece of legislation, each piece of code, each proposal, it all has its place and purpose, I believe. But it's about actually finding that nugget of commonality for everyone. That's the hardest part. And so that means really planning well in advance in terms of regulatory alignment. I think it's really important for discussions to be had and thoughtful discussions to be had with, policy, with government. Everyone needs a steer, and with industry, of course. And that engagement and dialogue and adaptation and innovation all requires, listening modes at all time. And I can't. I suppose I really can't emphasize that enough in terms of how important that is. The challenges are huge, of course, because it's very complex. And at the same time, for every organization, I always say context is king. It's so important to understand what it actually means to you in your organization, your industry, your government, whatever that is. And so in order to leverage, I think, AI to tackle some of the world's challenges, it's really important to ensure that these frameworks are complementary to each other. It's going to be impossible to try and line it up exactly, but this notion of being complementary to each other, I think, is really interesting. And fortunately, we have organizations like OECD, G7, UN, who are really kind of setting those global norms, which is fantastic. But the development of those norms at a global level, which links to, I suppose, like international norms and laws, that's the kernel, that's the piece in order to try and kind of emphasize that. And I think, governments will probably need support in terms of like helping to translate that and what that means in practice. Multi-party stakeholder is the obvious one in terms of participation there. And so I think overall what I would say, just to summarize, listening mode, engagement mode, multi-stakeholder participation, and acknowledgement of the work that has been done to date, I think is really important. And also that notion that those global norms and lining up to those international norms and laws is, I suppose, the North Star in that sense.
Thank you, Emma, for really highlighting some of this complexity and also some of the challenges that you're facing. And Audrey, I come to you last in this first round on purpose because we've kind of been building it up, from national and regional contexts. But there is also a very prominent role for international organizations like the OECD, in this entire ecosystem. So kind of bearing in mind the OECD AI principles that have already been out for some time, the OECD definition of an AI system, which was highly influential in ongoing negotiations on AI regulation. How does the OECD create spaces for international cooperation, and why is it important?
Thank you. Hi, everyone. It's great to see many familiar, friendly faces and to be back at CPDP. And thanks to fellow panelists for laying out some really important initiatives that are happening at the regional level, at the domestic level. You're all probably familiar with the OECD's AI principles that came out in 2019, but they didn't just kind of fall out of the air. They came from a robust multi-stakeholder process of engaging a lot of people who work in AI to develop, scientifically sound principles that could be implementable. We just updated them, and I think principles are important and they're great, but they're principles. They're soft law. They're not enforceable in a hard law sense. And so I like to think of sort of global AI governance as a set of concentric circles in some ways, where you have a lot of different needs, and they all serve a purpose. They're not mutually exclusive, but we will have to have hard regulation and hard law. And as my Canadian colleague said, existing laws apply, and new laws will come into play, and they will look different in different jurisdictions, even across a sort of very similar block like the OECD, where we have very similar governing structures and policy structures, but they're still different. So that hard law is going to look a little bit different everywhere. And that's okay. We just have to be okay with that. It's going to interoperate, and if we do a really good job, and we should do a really good job because we have a great opportunity to do a better job than we've done in some other domains and areas of technology policy. But it doesn't mean that we shouldn't have voluntary standards, and it doesn't mean that we shouldn't have norms, and it doesn't mean that we shouldn't have these sort of layers, if you will. And so from the OECD's perspective, our role is to really bring together people, multi-stakeholder. It's a cliche word, but it actually means something in our context, to do the technical work to build norms that can then be eventually used in other contexts, whether in treaties or in hard regulation. And I think you saw that we started doing that early in AI before it was a household name by a long shot, because to get to 2019, we started working on it in 2017, 2016. So, it didn't just happen in 2019. There's a lot of work that went behind it to get to 2019, and then a lot of work that's happened in the last 5 years that got us to some very small changes to the recommendation that was released, or to the principles that was released a couple of weeks ago, as well as an update to a definition. And I sat through the negotiations around changing the OECD definition of an AI system, which has been very influential in a lot of legislation, and it was hard. It was really, really hard, and it was hard because scientists have very different views on what is going to happen with AI. They have their very different views on what is going. It's not like there's a singular path forward, and so we have to run a policy and a global policy environment in the unknown, which is not unusual in technology. So it was really hard to get to an updated definition, but it was really necessary, because now that definition's in the AI Act, it's in the OECD, it's in Japan, it's being used in Canada, it's in the Council of Europe's AI treaty. So if we're talking about maybe not harmonization, but interoperability or coherent approaches across regions and countries, I think we have to start with both definitions but also terminology, and that's one of the things that I think that we do. We're a policy organization, but we're set up to be more technical than many other policy organizations. So, and we are set up to work in a multi-stakeholder way. I think one of the challenges with the current moment that we're in right now, which I'm probably preaching to the choir about, is that there is a proliferation of different, similar but different things coming from often the same set of people, players, countries, governments, whoever. And that makes it hard to say, I assume, I don't mean to speak on behalf of the organizations or the companies, I'm going to choose that code of conduct versus that code of conduct, and because they do use different terms. And it was one thing, if you just look at the AI Hiroshima code of conduct, they use the term advanced AI system for the first time, which isn't picked up in the Canadian code of conduct. And so we've spent months trying to figure out what an advanced AI system is, and we don't agree. And it's not defined. So at the OECD, we want to define it, and they don't want it defined because we want to be flexible about what we mean. And so I think that's a big challenge if you want to have codes of conduct or voluntary commitments where organizations are going to actually provide any sort of evidence or accountability to what they've done. And I think that's where the crux of the issue for governments, because I spend a lot of my time listening to governments. I spend a lot of my time listening to other people too, but I spend a lot of time listening to governments, and they want accountability. They want to know that these wonderful principles that they have, which are very good, by the way, and it was not easy to get to, that there's something behind a commitment to them, that it's not just, check the box. And so we're trying to put mechanisms in place to understand that, but every time, somebody releases a new code with different terms, it makes it hard to map what everybody's doing. So it's more of a pitch for, let's I guess, sort of in the spirit of the panel, we can convene. We're really good at that at the OECD. We can standardize. We can get agreement. We can get political agreement. We can get technical agreement. And we're usually fairly non-threatening, I like to say, in the sense that because it's not enforceable by, there's not a court that sits behind the OECD that's going to issue a judgment against you, people can come together and negotiate in a different kind of spirit. And I think that's what we're trying to do now. We've done for many years in AI, and we're trying to do now. I do think back to my starting point of the sort of, that we need lots of layers of different things, and we need soft law, we need hard law, but we should be starting from the same terminology. We should be consistent about what we're talking about. We should, and again, I'm not saying that's easy. It's really, really hard work. It's really, really hard work. And it's often thankless work, and it's not super sexy. But it does require having, again, sat through many difficult negotiations at the OECD, even among friendlies or countries that tend to get along with each other. It's hard, and it's hard work, but it's worth that investment up front. And so I guess I would say, I hope that just to give you an example, and then I'll stop nattering on because it's boring, but the example of where we're trying to harmonize terminology right now in order to try to make something coherent with the EU AI Act is around incidents and harm. Because it's great to say, report an incident, or great to say, tell me if it was harmful, but if you don't know what a harm is and how to classify a harm into different kinds of harms or different kinds of harms, then the reporting is meaningless. And if we've got companies, organizations reporting into the EU AI Act around incidents in one way and reporting into whoever else, because it will come everywhere, with a different way, then we'll never know in a cross-country comparable way if things are good or bad or better or worse or terrible or, there will be no point of reference that's useful. So, we have harmonized an approach to classifying incidents. We've harmonized an approach to classifying harms. That paper was just published, I think, last week or the week before. There's a whole bunch of people that have worked for 2 years at the OECD. You probably never heard about it because it's not, again, terribly sexy, but that have worked for 2 years at the OECD to fight about, what is a harm, which kinds of harms, and how do we classify them? So that I would encourage. I know sometimes we're not very good at publicity and we're not very good at saying what we've done, but these are all things that are foundational building blocks that, again, I hope the EU will take up in their implementation work of the AI Act, but not just. And whatever the regulation, the hard law looks like, whether you're in Canada or Brazil or Australia or Japan, all of these things, because everybody's going to take a risk-based approach. That's not like some novel, no offense, concept. I mean, that we're all going to have to assess risk. And so if we assess it more or less the same way, we can put risk tolerance at different places. And there's lots of disciplines and technology to think about: security, privacy. We're here to talk about data protection and privacy, where we've had these same types of conversations. AI is maybe a new technology in some ways, but there's much to learn from these other disciplines and how we understand risk, where we put risk tolerance, and what different cultures are going to do around that. And I don't think we need to fight about where your risk is versus my risk, but we should try to standardize our definitions, terminology, and what we're looking for, our incident reporting, things like this, so that at least we have a better grasp and a better picture on the world of AI.
Thank you so much, Audrey. That's really wonderful, and I look forward also to reading more about how this effort to define, harms and incidents, and how these definitions really come to life in the following months. And just briefly, I would come back to you, Commissioner Smolinek, from kind of your regulatory perspective. We've seen some very interesting work coming out, for example, from G7 data protection authorities, statements in the context of the Global Privacy Assembly. But how are these platforms for cooperation actually shaping, understandings of AI regulation? And also, it seems to me that one of the points where convergence is still perhaps necessary is around this soft law versus hard law approach. How do they kind of work together? How are you seeing this dichotomy playing out currently?
Sure, thank you, Bianca. So I'm not sure people are aware, but the G7 data protection authorities started meeting just a few years ago, I think in 2019, when the UK was chairing the G7, and the chair of the DPA roundtable of the G7 switches as the national chair switches. So this year it's Italy. Next year we're going to chair it as well. So as with everybody preoccupied with the AI, the G7 data protection authorities issued a joint statement on AI last June, and it is very much a key message of that statement is that current laws apply. So, among other things, the G7 DPAs called on developers and providers to ensure that privacy is built into the design of tools, from conception to operation to management, and that privacy by design principles are adopted. The statement calls for documentation of choices and analyses in the form of privacy impact assessments. It reiterates this very, very important point that I can't stress enough, that there's an obligation to comply with existing laws and adhere to applicable internationally observed key data protection and privacy principles, such as data minimization, data quality, purpose specification, use limitation, security safeguards, transparency, rights for data subjects, including the right to be informed about the collection and the use of personal data, and accountability. The statement also calls for measures to be put in place to ensure that deployers and adopters of systems also have the ability to comply with their data protection and privacy obligations. Key points of concern where risks might arise were noted, where the information and data sets used to train AI was obtained legally, whether the information used to train data sets was obtained legally, whether safeguards are in place to protect the data sets from attempts to extract or reproduce the information, whether AI tools have mitigation and monitoring measures to ensure personal information is accurate, up to date, and free from discriminatory unlawful effects. We're also concerned that transparency measures be put in place to promote openness and explainability in the operation of generative AI tools, especially in cases where such tools are used to make or assist in decisions about individuals. Our office also welcomed the G7 Digital and Technical Ministers Declaration of April 23, which reinforced that the position that AI-related laws, regulations, policy, standards should be human-centric and based on democratic values, including the protection of human rights and the fundamental freedoms and the protection of privacy and personal data. And I note that in our view and in international instruments, privacy is a human right. On the national level, we've done something similar with our provincial and territorial counterparts, issuing joint statements. But before that, or at this event, we organized an international symposium on generative AI last December, well attended, that coincided with a meeting of the Berlin Working Group, which is a grouping associated with the Global Privacy Assembly that brings together technological experts and privacy experts. So at that event, we issued this federal, provincial, territorial statement on responsible use and development of generative AI. Key principles included legal authority, establishing legal authority, openness and transparency, making AI tools explainable, and developing safeguards, limiting sharing of personal and sensitive or confidential information, and taking into consideration the effect these tools can have on vulnerable populations, including children. Another international initiative, and I think I'll leave you with that, is one that we participated in at the Global Privacy Assembly, which adopted a resolution on responsible generative AI. And the resolution called on developers and providers of generative AI to embed privacy in design. Again, a reminder on the need to comply with existing law. We furthered committed to exchanging information and learning from the experiences of our counterparts. So there is actually an AI working group as part of the Global Privacy Assembly as well. What else can I tell you? Oh, just another international event. So I misspoke. It's not the last thing I'll leave you with. We, along with 11 data protection authorities, issued a joint statement calling on social media companies to prevent unlawful scraping of data. And that statement urges companies to put controls in place to protect against unlawful scraping and to respond when they are suspecting of scraping happening. So what else?
I think that's a wonderful overview.
That's it.
Yeah, that's a really wonderful overview. Thank you so much. Really interesting to hear more about the G7 declarations and looking forward to seeing how that work continues for data protection authorities in this space. Bruno, I would turn to you also quite briefly. As you know, I've had the honor of supporting Gabriela Zamfir Fortuna in her participation in one of the task forces of the G20, which you are co-chairing. So I'm curious then, from the G7 to the G20, how are you seeing authorities in that context, civil society representatives, other stakeholders coming around for this conversation in the context of this group?
Thank you, Bianca. Yes, so I will try to provide some overview, but also a biased overview because I'm in a specific engagement group, which is at T20, the think tanks engagement group. So we'll try to build somehow a bridge between C20 and S20, civil society and science 20. But anyhow, before to go to that specific topic, I think three kind of footnotes. I think it was very, very important the work that OECD did when they shift the terminology from harmonization to interoperability, because it's almost impossible to have a universal approach because context matters a lot. And also because we have to have some kind of alignment, but also recognizing the difference, also the opportunities, the risks, and also the damage that we are seeing with this technological progressive or the technological development. So for instance, when we are talking about artificial intelligence, not just about harms, a future discussion, but also about a present discussion on damages. So for instance, Global South is being hurted a lot with regards to the material effects, the human infrastructure behind artificial intelligence. So the environmental side effects of this whole life cycle, the illegal extraction of natural resources is being done in Africa, in Amazonia, and other parts of the globe. And we have seen this before with other new waves of development in the past year. Also, the whole discussion about reskilling and the work, like the whole infrastructure of data labeling is being done in a kind of slavery, kind of dynamic work that is hurting specifically the global majority part of the world. So when we are thinking, and I think Audrey did and highlighted very well this point, when we are thinking about this interplay between soft and hard law, it's good to open some kind of avenue in order for we do our domestic work by prioritizing some kind of protection, some kind of rights, some kind of also political and normative messages. And the third footnote, I completely agree that we have this underlining alignment in terms of regulatory rationality of a risk-based approach, but we are seeing a lot of nuance between this regulatory interoperability, because at the end of the day, we are also having a discussion how we are going to have an effective democratic oversight about the risks. So we establish a comparison from Canada to Brazil, to European Union, or the Chile regulatory proposal. We could see some difference, and those difference matters a lot. So we have to pay attention also for this regulatory affirmance, how we are going to fortify democratic governance. Otherwise, we are going just to see another beautiful words, beautiful principles, accountability, no malfeasance of AI, without having a substantive protection. And at the end of the day, also a responsible innovation, because no one wants any kind of innovation, but responsible innovation. And how we can see this in the Brazilian presence of G20 work. First of all, a kind of continuity, because for the first time we are having a South-South troika. So we started with Indonesia, then came India, now Brazil, and next year South Africa. So we are trying to establish a continuity of those policy conversations by highlighting the importance of combining right now soft laws and hard laws to govern AI instead of being governed by them, and also in a long and a medium term, how we are going to combine regulation with public policies in order to strike digital sovereignty. So, for instance, the whole discussion that we had about digital public infrastructures during the India's presidency, we are trying to move forward with this discussion, but in a sense that we should have a critical perspective. And what I mean by that, by having a common approach with regards to data governance. Because if you think about not only about the benefits, but also the risks, the harms, the damage, we are still having the same discussion of not having a proper enforcement in terms of data governance. AI and other future technologies, they have to fulfill by data. And one of the most pressuring issues related to the Global South is how we are going to produce data, and also how we are going to have proper methodologies in order to strike a balance between some groups that are invisible and sometimes hyper-visible on it. So, for instance, G7 did a great start by highlighting we should have a transnational solidarity by highlighting the importance of AI to solve the greatest challenge of our societies, for instance, climate change, for instance, poverty, and so forth. And this is very alignment with the Brazilian presidency, and also somehow breaks some kind of myths that we should have always large language models to solve those kind of problems. Sometimes we have just to have small data to develop a specific kind of AI that could be even more efficient and even more compliant with data protection laws by being compliant with accuracy principle, quality, the principle of quality, the whole idea about data minimization, and so forth. So one thing that is driving our work in T20 is this idea about data justice. So at the end of the day, we should have this kind of image that the roots of our tree, of our society, is still a discussion about governance of data. Because then we can have like the access of a tree, such as AI as a foundational model, or other kind of technology, and try to prune the top of the tree by taking back the structural problem, which is about data governance. So for instance, another concrete example, like in Brazil, we are seeing a lot of initiatives, very interesting initiatives about citizen generation of data, because sometimes some public policies make even more invisible who is in the peripheral areas in Brazil. So they are producing data to say, I'm here, and you have to take into account that kind of data that make even more diverse and even more equal the public policy for electricity, for whatever. So we are having that kind of a discussion, I think right now in G20, specifically in T20, to take a step back and say we have to have a proper approach on data governance. That means a lot, and then we have to fulfill some kind of gap, historical gap, in terms, for instance, the gap of enforcement of data protection laws, because we are reaching the 5th generation of data protection laws, and we are still trying to improve something that we have more than decades in terms of history.
Thank you. Thank you so much, Bruno, also for highlighting this Global South dimension and also the crucial element of transnational solidarity that you mentioned, that's also mentioned in the context of the G7. And I would come to you next, Emma, just for my last question to you. And Bruno touched on some of the data protection principles. That's really the focus in the G20 dimension. But beyond kind of data protection principles that you've been so familiar with for such a long time, what are some of the other kind of requirements and principles that are coming to play for you in practice? You know, for example, looking at safety, security, and so on.
So again, I suppose I go back to we were founded as a research lab, right? So obviously, in that sense, safety was very much part and parcel of what was done every day, again, prior to November 2022. And so that has remained unchanged and continues. So I think what's even more apparent is the importance of all of these different teams that exist, not just in our organisation, but in others as well. So you do have the safety teams, but you do have, the red teamers, for example. I work with them myself. You also have the, we've talked about like the preparedness framework that we have in place. But I do think from a data protection perspective, I still go back to that because there's so much to draw from the work that's already been achieved. And I still go back to everything that's been done to date because there has been so much. There's a lot of muscle memory already in terms of, for example, how we approach data protection impact assessments and so on, and LIAs, etc. So, that muscle memory is going to be very useful going forward, I think, for companies, and that's definitely what I'm hearing from a lot of different industry colleagues that I speak to. So it still kind of goes back to that critical foundation. The other one as well, I will say, and it keeps coming back, and I know I'm talking about the data protection sphere, but it is so important. And it's that notion of, privacy by design. We've heard about this over and over. Of course we have. And again, all these terms are really loaded and meaningful, but they're no less important. They're really, really crucial. Definitely seeing that come to the fore quite a bit. So I know your question was more along the lines of like non-data protection related, but it still keeps coming back because it just goes to show how important those grounding principles are. And, you know, GDPR is still, you know, very young, and yet, you know, it's created some really fantastic concrete principles that we can work from. You know, the accountability aspect of things and the transparency aspect, you know, that is going to be, I think, a very, very core focus for everyone going forward. The best way to do that, and that's going to involve, again, so many people within an organisation, so many guidance, so many principles that needs to be, you know, garnered from lots of different corners of the world. You know, everything that's been described here already is going to be included within that. So I think that layered approach on, you know, both data protection principles, foundational ones, and non-data protection will continue to happen. It has to, because that's the nature of how it works. And of course, it all has to happen very quickly and very fast. And that's why being very aware of kind of your mission, your principles, your standards. Again, context is king. I keep saying this all the time, but it's so important. That's where I think those principles come into play. With that, of course, as well, you know, it's all well and good to have all of these principles, but at the end of the day, it is about the prioritization. And so, like any organization, you have to kind of prioritize something, one versus the other. You know, it's not possible to do everything. And, you know, for us, of course, obviously, there's some very core principles that we talk about. We actually issued our charter just a few weeks ago as well, which goes into that in a bit of detail, which no time now, I'm afraid. But that, you know, does kind of highlight, at least for us, you know, what is important. And so, yeah, I think those principles remain the same, to be honest. And sorry, I know you were asking non-data protection, but I have to. No. I still go back to my core, my core school of thought.
But no, that's great to hear. I mean, data protection is still very, very important and very central, even though we're talking a lot about AI. And Audrey, for my last question to you, I'd be very curious to hear, you know, what are some of the challenges that you're seeing in the international dialogue efforts? And more directly, I guess, do you think that interoperability that you mentioned of legal frameworks is possible? What do you think is needed to get there?
Well, I think I maybe already answered your question in my prior response. So I don't know if it's maybe more interesting to take questions from the audience, since we only have 5 minutes left.
I think we can do that. Oh, yeah, we have 5 minutes left. So just for some questions from the audience, I think there's the first one here.
Thank you very much. A question from the floor. Maybe I'll stand, actually. So this is Ben Avison from RAID. RAID is a conference about the regulation of AI, internet and data, which we launched in 2016, which is about the same time frame that the OECD, you said, has been working on the global regulation of AI. So much has been achieved since then. We perhaps couldn't have envisaged an EU-wide AI regulatory framework for AI in that time frame. I'm interested to hear what the panel think about where we might be in another 8 years' time when it comes to global AI regulatory frameworks. Could we see an expansion? How far might regulatory alignment on AI go in that time frame? Or will geopolitical concerns and erosion of trust between different countries in the world get in the way? The conference is RAID. It's on the 23rd and 24th of September. Please come.
Would someone like to take that question?
There's going to be one law that everyone's going to adhere to, and everyone's going to be holding hands, and everything will be great. Look, I think you kind of answered it in your question, which is, you know, there are certain cultural mindsets in various, you know, countries, obviously, and you know, as Audrey's highlighted as well, like that is going to be. It's just so hard and it's so complex. But I do think, I don't know, from my perspective, I do think, you know, and I am seeing such a want to collaborate and to talk and to discuss and to engage more than ever. So I think that's something that we can really kind of hold on to, I would say. I don't know, does
I'm starting to
answer.
salivate. Did you say 8 years?
I'm wow. That's the question. 8,
usually it's 5 or 10.
That's a long time. So, yeah. So that's what the first thing that comes to mind as that's a long time from now. Well, 8 years seems to be a long time, and given the pace of technological evolution, I'm not just talking about AI. So I'm wondering about what else may come up that we haven't really anticipated. And then you, I think yourself alluded to geopolitical conflict as well. That's already having its effect, I think, on whatever it's called, sharing of AI tools across borders, and so that's already having its effect. So a lot of contingencies in that 8-year time frame that I think will affect how things evolve.
Thank you. Hope that answers a little bit. All right, and I think we're at time. Thank you again to all of our panelists for your contributions, and to all of you. Enjoy the rest of the conference.